Yes, Mr. Manning. I can tell you that we've read both judges' two judgments, and we have also read the skeleton arguments.
That's very helpful, thank you. And no doubt the court will be aware of the representation. I appear for the appellants, to get them alone from Mr. Clegg, who sits behind me, and Mr. Kangure appears for the respondents.
Yes.
He also appeared below. Your lordship, or the court will have seen that I appeared below at the consequentials hearing, but not at the actual
Yes.
trial. So I propose, subject of course to the court, to deal with the issues in the following order. The question of the existence or otherwise of a quasi-partnership, the ownership of the technical library, the diversion of the project and breach of fiduciary duty, and then the questions on remedy of minority discount and date of valuation. So if I can start with the question of quasi-partnership. It's our submission that it's clear on the authorities that at the heart of the concept of a quasi-partnership is the need for a personal relationship of trust and confidence akin to a partnership, sometimes referred to as being analogous to a partnership, such that equitable considerations arise which make it unjust or inequitable to rely on strict legal rights. Now we say formulations of that kind are present variously in the more modern authorities. I'd refer the court for convenience to Ray Edwardian, which is in the bundle. I don't think we need to go there unless the court would like to.
Sorry, which case?
Ray Edwardian, which is the decision of Justice Fancourt.
Yeah. I think your skeleton refers to Fisher and Cadman as well, which is Mr. Sales' decision.
Yes.
Can I just ask you this? The judge found breaches of the express terms of the shareholders agreement.
He did.
And breaches of directors' statutory duties.
Indeed.
So what is the significance or otherwise of quasi-partnership, save possibly for the starting point on the minority discount question?
Well, that's a very fair question. And indeed, my answer to that can only be that it only goes to the question of the remedy. The reason for raising it at the beginning is first because it does go to the question of remedy, therefore it will have to be considered. And in terms of the logic, if you like, of the sequence, it sets out and analyses the relationship between the parties. And that precedes, in my submission, considerations of, well, what did the parties then do? So that is why I started with it. I can perfectly well see, my lord, that it could also be convenient to say, well, actually, in one sense, that doesn't matter until we get to the question of remedy. So I'm in the court's hands.
No, you take it in your own order. I just wanted to clarify the significance of the point.
I think that's entirely fair when one reads the judgment. And this, of course, we say, is a relevant consideration when you're looking at the whole question of whether there's a quasi-partnership, is that the sort of equitable considerations that overlay the normal contractual provisions that arise out of the nature of the relationship simply aren't here. They're not found to exist by the judge. There are no, I'll come to this in a bit more detail in a moment, but there are no prior understandings or agreements relied on that could give rise to extra contractual equitable considerations. And moreover, and it's a separate and additional point, the judge does not find that the contractual provisions themselves gave rise to considerations that were capable of either restricting or amplifying the scope of those contractual provisions. And there are certainly cases where that's being considered as a possibility, but the oddity of this case is that the equitable considerations don't arise even in the sort of formation of the agreement or in the question of, well, what have the appellants done wrong? as your lordship rightly points out, it's simply a contractual question. We say that is actually relevant to the analysis. So we start with that general proposition, and obviously it's well known that the paradigm case for the existence of a quasi-partnership is where there has been a pre-existing partnership, and the parties convert their relationship into a limited company, and in such cases, the underlying fiduciary duties owed as between the partners can, in some form, be carried over into the corporate structure. Because typically, those fiduciary duties will not themselves be capable of being carried over into the corporate structure. So they overlay, if you like, the strict constitutional provisions of the arrangement. So as we were just discussing, this is an unusual case in the respects that we just discussed. No agreements relied on, no understandings relied on, and no restraints said to have either A, exist, or B, to have been breached. And we see that, but from the judgment of Para 157, to which I was going to draw your lordship's attention, but the reality is it appears the court is already completely on top of that point. It's the paragraph 157, where the judge finds that the relationship has to be found in the 5 documents. So it might be worth turning that up, because it's a slightly wider point, perhaps, than the one that your lordship has drawn attention to. So I think the judgment is behind tab 7.
Yeah.
And relevant paragraph is para 157.
Yes.
And your lordship sees that the judge agrees with Mr. Reed, who appeared for the appellants below. The court is required to interpret solely, and I emphasise, the 5 documents executed on 2nd of October 2012. And then he, the judge, goes out to set out certain characteristics that arise out of those agreements. So the point is this: not only does he not find breaches of anything other than contractual provisions, but he doesn't even locate his decision, his consideration in any area other than those contractual provisions. And of course, he will have been influenced in that respect, at the very least, by the existence of the entire agreement clause. And the court will be aware that, that such clauses in this environment have been found to have the effect of barring consideration of any prior agreements, understandings, etc., which obviously conflicts with the whole the general concept of a quasi-partnership. So we said the judge made no findings as to the relevance of any prior association, and it's clear in his conclusions, which are in paras 157 and 159, to which we'll come in a moment, that he was relying solely on the terms of the agreements themselves. It appears, reading my learned friend's skeleton argument, that the respondents may be tempted to suggest that the scope of the judge's inquiry went wider than that. But we say the judge is absolutely clear in his approach in this respect, and he's just looking at those 5 documents, the contractual provisions, and seeing what the consequences of them are. So we say the starting point, therefore, is as follows. The parties chose to operate through a company in the first place. The venture was purely commercial in nature, involving various shareholders with different roles. In order to regulate the relationship between those shareholders, detailed documentation governing the various aspects of the relationship were negotiated and agreed. And talking of various roles, which is a point we'll probably come back to, one of the elements of the relationship that the judge doesn't seem to have given any specific consideration to is the role and function of Mr. Shield, the director of SES. And the court will recall that SES granted the company an option to purchase the lines which are at the centre of the project with which we are concerned. and also was independently a lender to the company. And he obviously was only introduced at the very last minute. Whereas it is fair to say, as the judge noted, that others had been involved in varying ways in the project in an informal way prior to that. Now, in my submission, that ought to give rise to very particular considerations when you're looking at the concept of a quasi-partnership, because it's very clear that Mr. Shields' role was capable, his interest in what was going on through his company SES was very capable of conflicting with the interests of the company. He was acquiring the lines, he was selling the lines pursuant to an option, he was lending money, and that potential for conflict was avoided precisely because, or dealt with perhaps I should say, precisely because the parties entered into carefully drafted documents that provided for the manner in which the various rights and obligations should be exercised. And your Lordship, the court will have noted that the judge accepted SES's right to sell the lines once the option had expired. Now, in a looser partnership arrangement, it is, in my submission at least, quite conceivable that the subordination of one party's interests to those of the partnership as a whole, and therefore to the other partners, might well have given rise to consideration of equitable constraints on Mr. Shields' ability to walk away, as far as the lines were concerned, from the project. But none of that arises quite properly because the parties have worked out their relationships in a proper commercial fashion. They haven't left it to underlying duties, fiduciary duties of uncertain scope. And of course, the purpose of those underlying fiduciary duties of uncertain scope is precisely to cater for unforeseen situations in the development of a business. That's not what's happening here. The parties have thought very carefully about the interrelationships and the rights and obligations, and they've provided for them. Of course, the key document is the shareholders' agreement. The judge talks about the 5 documents, but in reality, at the centre of it all is the shareholder agreement. Worth noting, of course, right from the outset that contains an entire agreement clause, that's clause 17, and a no partnership clause. And we say, in such circumstances, that there is simply no room for equitable considerations or any concept of a quasi-partnership. And of course, note again in passing that when we say there's no room for equitable considerations, we're not even trying to banish what the judge found, because he didn't find any equitable considerations. He simply found a quasi-partnership, which really makes one feel that that's just a label, that's just a term. I mean, no disrespect to the judge in saying that, but what I mean is that absent those equitable considerations, what he's really meant by saying this is a quasi-partnership, something akin to a partnership. It's worth pausing at that point just to consider the role of detailed written agreements in this kind of analysis. So in paragraph 43 of his skeleton argument, my learned friend makes some points about the issue of detailed written agreements by reference to the text, which perhaps the court is familiar, written by Mr. Joffe, Minority Shareholders Law, Practice and Procedure. And he, in responding to our point that a detailed written agreement is, or agreements are generally considered to be factors to be taken into account against the existence of a quasi-partnership, he makes the point that where the members' agreements or understandings are set out in complex written agreements, whether a quasi-partnership remains contextual, he says. So you've just got to look at all the facts. And of course, up to a point, it's always contextual, and I accept that. Of course, you've got to look at the facts, but that doesn't mean you can simply wash away the importance of the parties having thought carefully through the various relationships. And the critical point really is C, which, to be honest, I think really makes our case for us. Summarising what is said in Mr. Joffe's textbook, he says it's necessary to consider the parties' relationship as a whole if, despite the detailed documentation, the relationship qualifies as a quasi-partnership. Now, if we actually look for a moment at, if we could, Mr. Joffe's textbook, it just adds a little to that. I think it's behind tab 22. So towards the back, London's falling apart already. So. Tab 22. If the court could look at paragraph 6106.
Yes.
The question of whether equitable considerations can arise in such a case is necessarily one of fact and construction. No dispute with that. The mere existence of complex written agreements does not necessarily exclude the possibility of the existence of some other arrangements or understandings between the parties, express or implied. It's necessary to consider the parties' relationship as a whole. And that's the point. What's being said is, yes, there may be written agreements. That doesn't necessarily exclude a quasi-partnership. There may be other things. But the point is there are no other things in this case. There may be other, what's the expression used? Other arrangements, none are identified or relied upon by the judge, or understandings between the parties. There aren't any. It's all there in those complex documents. And so we say that the existence of those detailed, worked through documents is a very important feature. And what it gives rise to is the conclusion that the parties' relationships was entirely contractual. There it is, in the contracts. Of course, there are fiduciary duties owed by the directors to the company, but as regards the relationship between the shareholders themselves, it's all there in the contract and it isn't anywhere else.
Yes.
And it's worth then pausing for a moment, if I may, on the entire agreement no partnership clauses. The entire agreement clause appears at clause 17.1 of the shareholder agreement, which is behind tab 14 of the supplemental bundle. So it's perhaps just worth picking it up so we see the terms of it.
Yep, page 66.
Yes, thank you. So in fairly standard terms in my submission, agreement, any documents, photos, etc. constitute the whole agreement between the parties and supersede all previous arrangements, understandings and agreements between them, whether oral or written, relating to their subject matter. That is normally, of course, inimical to the existence of a quasi-partnership. Here, the oddity is that the judge isn't even trying to do that, perhaps in recognition of that, but also the facts that were before him in my submission. But there is also, of course, the no partnership provision.
Clause 21.
I thought that was clause 22, or perhaps. Oh no, your lordship, you're absolutely right. My mistake. Sorry. No partnership. Yes. Parties to this agreement are not in partnership with each other, and there is no relationship of principal agent between them. So the question is, what's the impact of these? And we refer in our skeleton argument to the other textbook that is commonly referred to in these sorts of circumstances. That's the textbook written by Mr. Hollington. And just to pick it up, paragraph 742, which I think is behind.
Sorry, where are you now?
The Hollington Shareholder Rights textbook, which is tab 21.
Right.
Of the
Tab 21, yep.
authorities. And at paragraph 742, Mr. Hollington makes this observation: entire agreement combined usually with no partnership clauses will usually negative the existence of a quasi-partnership. He refers to the George and McCarthy case. And then, skipping over the second paragraph for the moment, in Ray Edwardian, the court held that a quasi-partnership in a very substantial family-owned commercial business with a large employed professional management team could not exist where there was a detailed shareholder agreement which included an entire agreement clause. That's focusing on the entire agreement element. Now, in one sense, we submit that the entire agreement aspect speaks for itself, but we say Mr. Hollington's proposition must be right as a general proposition, because the entire agreement clause prevents reliance on prior agreements, etc. And the no partnership clause makes clear that the provisions of the agreement itself are not intended to give rise to rights and obligations in the nature of a partnership between the shareholders. So the same relationship that exists in a partnership is not to be found in the terms of the shareholder agreement.
You have to interpret that a little bit loosely to make your point, though, don't you? Because it's obvious that the shareholders in a company are not in partnership.
Right.
So you have to read partnership as meaning quasi-partnership.
Well, in a sense, that's what the judge said. Your lordship.
Well, the judge said it's not, no partnership is not inconsistent with quasi-partnership. But I think your point is, well, that gives clause 21 no meaning at all, because it's obvious that shareholders in a company are not partners.
Well, exactly. And so to give it force, and we will see an example of that, not act strictly in an unfair prejudice context, but in a context which I would submit is directly analogous, the court approaching it in very much the way your lordship says. What significance would it have? What's the point of saying no partnership arises out of this when it's blindingly obvious that no formal, or as the authorities would have it, true partnership arises? We know that can't happen and doesn't happen. I think that the point really is this: it comes back to this point that quasi-partnership is a label. You wouldn't expect to see a contract saying this agreement does not give rise to a quasi-partnership, because what would that even mean? It would be on its face be very difficult to interpret. What did someone actually mean in that context by the expression quasi-partnership? But where you have a clause of this kind, in my submission, what it's saying is that the relationship of partnership, or the nature of that relationship, does not arise out of this agreement. And of course, the central component of that is fiduciary obligations as between the partners. And in my submission, it can readily be construed in that way. But I'd say this in addition: even if you couldn't get to the point of saying, well, that clause actually bars any finding that there's a quasi-partnership, even if you couldn't get that far, and I submit that you actually can, the reality is that you've only got to look at what's going on here to see the force of that clause. The judge is saying, I find a quasi-partnership by reference only to the terms of the agreement, and yet contained in that very agreement is a clause that at the very least is talking about the analogous relationship. So what would have to be found is, well, the parties may have agreed that they didn't want to be partners, but that doesn't mean they didn't agree they didn't want to be quasi-partners. And if you're looking at the true intent of the agreement and the nature of the parties' relationship, which is the focus of the quasi-partnership analysis, I would submit that simply makes no sense. That to say that there was a quasi-partnership, notwithstanding that the only focus of attention is the agreement, and the agreement contains a clause that says no partnership. So I think there's sort of two related ways of putting that. One is that it is actually a contractual bar. The other is that it is such a forceful element in trying to determine what the party's intentions was as regards their relationship that it pretty well overwhelms everything else. And particularly in circumstances where, sorry to repeat the point, there actually isn't anything else.
Yes.
And it may just be, just to pick up on the related point that we touched on a moment ago, if we look at the judgment in para 156, that's going back to tab 7. Yes. The judge's point, as I understand it, seems to be this. The fact that shareholders are not partners, he says, as a matter of law, doesn't prevent a quasi-partnership arising. Point one of the analysis. That's right. So it must be the case, he says, the judge concludes, that any clause negating the existence of a partnership will equally not prevent a quasi-partnership arising. That's as I read the reasoning in that paragraph. This then takes us back to, I think with respect to your lordship's point, that if that were correct, it's hard to see what impact such a clause could ever have, because on his analysis, no partnership could ever arise. But we see, and this is now where I'll take the court to the relevant authorities, that such clauses do have effect. The court does give effect to clauses of this kind, as one would expect. It'd be very surprising if clauses of this kind, which are so frequently employed, had no effect and yet continued to be employed.
Mr. Mallon,
yes,
slightly. The point of these clauses is to say there's no quasi-partnership, since it's obvious there's no partnership. Why don't they say no quasi-partnership?
Well, I think with respect, for the reason I think that I said earlier, which is that a quasi-partnership is a label attached to attaching.
But I don't understand why that's a reason why, if that's what the point of the clause is if the purpose of the clause, as you're putting it, is to say that this label shouldn't be applied, it seems a very elliptical way of doing something which could be done in a more straightforward manner by saying this label, quasi-partnership, shouldn't be applied.
Well, you would never know whether a quasi-partnership as such exists or does not exist unless and until, in effect, you've been through a court process of this kind. It's not a label like a partnership. I know what a partnership is. I can very easily take legal advice as to whether I'm in a partnership or not. Quasi-partnership is simply a label that arises in cases of this kind to describe an almost limitless set of circumstances. I have to say, I have never seen a term to the effect that there shall be no quasi-partnership arising out of this agreement, not least, my lord, because it's very unusual even to suggest that the quasi-partnership arises out of the agreement, rather than saying that the terms of the agreement and the provisions and effect of the agreement are actually modified by other considerations. So it would be a very unusual thing in a way for that to happen. Of course, one could always say, well, whenever there's a dispute about the effect of a clause, well, wouldn't it have been easier to do that? But I have to say, in my submission in this particular respect, my lord, that would be very unusual. Well, indeed, as I said, never seen it at all. Would be hard to understand in some ways as a specific provision. But in any event, one comes back to the point that it's the substance of the relationship that we're trying to discern. And if the sole point of focus is an agreement that contains a clause that says there is no partnership, that tells you, in my submission, even if it's not that absolute contractual bar that I put forward as my primary case, that tells you that the party's underlying intention cannot have been to create a relationship of the kind that is encapsulated in a partnership. I don't know whether that fully answers your question, Lord, but of course, at one level, your lordship's right. If it just said that, it would be an awful lot easier. But sometimes that sort of observation has more effect than others. So, you know, we're very used, aren't we, to saying when we're interpreting a contract, well, you want to imply that term, but why should, if the parties had wanted to say that, they could readily have said it, and sometimes that'll be quite conclusive. I hope, for the reasons that I hope I've explained, I would suggest that it doesn't have anything like that force here. One looks at the thing in the round, and the role of that clause when looking at the issues in the round is one of considerable significance in my submission. And bear in mind that clause 21 is framed broadly. It talks about not in partnership with each other, and we say even as a matter of construction, it must be right that negatives any intention of the parties to create the relevant relationship. So if we then turn against that, those sort of background observations to the judge's actual findings, I think the best place to start is paragraph 157 of the judgment.
Yes.
And the court will see that the judge there sets out what he describes as the central obligations relevant to the quasi-partnership issue in my judgment, and he lists them out there. And the court will have seen what those are, and we're going to come back to them when we look at the breaches. So then we look at paragraph 159, and that sets out a number of reasons why the judge arrives at the conclusion that there is in fact a quasi-partnership arrangement in this case. I'd like to start with the concept of good faith. Does the court see just 2/3 of the way down the words, they all owed duties under this of good faith to each other. So there was a relationship of mutual confidence. Now obviously the question of the personal relationship of mutual confidence is the very heart of the question of quasi-partnership, as I mentioned right at the outset. And so it's important in my submission to begin with that, because that's really the central plank. In my submission, if the judge is wrong about that, then essentially he must be wrong in his conclusion, because there'd be no relevant duty of trust and confidence. And so we see that the duty itself, the duty of good faith, is at clause 22.2 of the shareholder agreement.
He quotes it at page 83, paragraph 22 of his judgment.
He does, yes. So if the court's content with that.
Well, unless you want us to look at more of the shareholders
No,
agreement.
not for present purposes, no, my lord. So we say that it's clear on Court of Appeal authority that there's no equivalence between a contractual duty of good faith of this kind in these terms and a fiduciary duty owed between partners. And for that proposition, I'd like to take the court to the compound photonics case behind tab 19 of the bundle, of the authorities bundle, that is.
Nineteen, you say?
19, please, yes.
Yeah.
So your lordships will see this is a decision of the Court of Appeal in October of last year. If we just to pick up some context, look at paragraph 2. The core of the case for the minorities, which the judge accepted, and that was Mr. Justice Adam Johnson, was that they had been unfairly prejudiced by the investors when Dr. Zacks and Mr. Faulkner were respectively forced to resign and removed from office as directors, and thereby excluded from any continuing role. So it's an exclusion case, essentially. Now, note the following paragraph. It was not, however, common ground that the company, it was, however, common ground the company was not a quasi-partnership. That's why I say the good faith submissions that I've got here and the impact of them are not in the context of a quasi-partnership case, but one in which, as I hope to demonstrate, arises in a directly analogous circumstance. So if we just go over the page, the court will see that in paragraph 4, at the heart of the judge's decision was the finding the shareholders' agreement and the company's articles comprised what he called a constitutional settlement reached between the shareholders, under which Dr. Zacks, that's one of the excluded persons, and Mr. Faulkner were entrenched in office as directors, even though the investors had provided very substantial capital for the company's business and as a result had 93% of the shares. And then importantly, paragraph 5, there were, however, no express terms of the shareholders' agreement to that effect. So, judge found that there was some form of restriction on the ability to get rid of, to put it crudely, Dr. Zacks. But there were no strict contractual or other provisions to that effect, and it was not a quasi-partnership. And the court will see at paragraph 6, the judge held in particular that the good faith clause required the investors to act with fidelity to the bargain, and the bargain the investors had made was expressly designed to avoid the will of the majority prevailing in matters concerned with the commercial future of the company. So, if you like, what is being relied on there is a term of good faith in order to do what many people relying on a quasi-partnership would seek to do. In other words, say, well, look, I know there's nothing there in the strict terms of the arrangement, but in equity, or here pursuant to a clause of good faith, it must be implied, or there must be imposed a restriction on the majority's free will. And we see the nature of the appeal from paragraph 7. The investors' appeal, essentially on the basis the judge interpreted the good faith clause in the shareholders' agreement far too widely. They contend it didn't, that the clause did not mean they had given up the right to vote to remove Dr. Zacks or Mr. Faulkner, or take control of the management of the company, etc. And then if we could just go to paragraph 141. And just after that, in fact, beginning at 142, the central issues on the appeal. And we see at paragraph 143, he starts off with starts off in 142 that in principle judge was correct to approach matters on the basis that in the absence of a suggestion the company was a quasi-partnership, although there were some other grounds for the imposition of equitable constraints. Then the question amounted to an issue as to whether the members had agreed the affairs of the company should be conducted in the relevant way, and went on to say in 143, in that respect, as is apparent from my lengthy summary of the judge's reasoning, the majority of his findings of unfair prejudice depended upon his interpretation of the content of the obligation of good faith in clause 4.2 of the shareholder agreement. And just so that we have that in front of us, that I think is set out at paragraph 78. It's worth a glance back. I should have picked it up all the way through. You say that's a fairly standard form for clauses of this kind. Each shareholder undertakes to the other shareholders that it will at all times act in good faith in all dealings with the other shareholders in the company in relation to the matters contained in the agreement.
Yeah.
And then, if we just go over the page, we'll see a heading, the meaning of clause 4.2. And there are some various observations about why the clause must take its meaning in context, etc., which of course is right, and I don't take issue with any of that. Then we come to the heading over the page, just over ahead of paragraph 152, heading procedural fairness, because it was said that one of the consequences of the clause was that it gave rise to certain obligations of procedural fairness which were breached in respect of Doctors' Acts. You'll see that the final sentence of 152 says, the only basis for his conclusion that clause 4.2 is intended to impose such a duty upon the investors, i.e. not to remove Doctors' Acts, was that such a duty had been found to exist in a number of earlier authorities. And he deals with, the judge, or the court there, sorry, refers to Mullings and Lofton, and your lordships will see that Mullings and Lofton, paragraph 154, is a partnership case which did not concern a contractual duty of good faith at all. And we come then to the paragraph that we principally rely on, which says that in my judgment, there is, however, no equivalence between the duty of good faith imposed by law on partners, between whom there is a fiduciary relationship, and the agreement made between the shareholders of the company in the instant case. The shareholders had expressly agreed by clause 23 of the 2013 SHA that their relationship was not to be one of partnership and that they owed each other no fiduciary obligation.
So that's deploying the no partnership clause for a slightly different purpose.
Yes, my lord, but we say analogous because what we're concerned with here is whether the judge is right to rely on a contractual good faith clause to say that that established the relevant relationship of trust and confidence, giving rise to a quasi-partnership. Now, if we assume that a quasi-partnership is in substance, and that's the term from the Ebrahimi case itself, is in substance a partnership, then if you're going to determine whether the relevant duties have arisen between, in this case, the shareholders, you have to determine that those duties amount to fiduciary duties, the same fiduciary duties that would exist as between partners.
So you're focusing, is this right, on the sentence in paragraph 159 of the judge's judgment, a few lines from the bottom. He says they all owe duties under the SHA of good faith to each other, so there was a relationship of mutual confidence. And you are saying, in effect, that conclusion does not follow from the premise.
Absolutely, my lord, yes. And moreover, that because it doesn't, that was not even a relevant factor, because it's all you're doing when you look at a contractual good faith clause is say, well, there's what the parties have agreed as between themselves, unless you can elevate it. If you can elevate it in some way, then it may start to become relevant. But my point is you can't elevate it in that way. It is what it is. It's a contractual obligation of good faith, no more and no less. So the judge's way of expressing it, so, as your lordship points out, yes, I agree, that is flawed as a matter of logic. But in fact, taking account of the good faith provision, it is fundamentally flawed itself. So even if one said, all right, well, the so doesn't work, that direct correlation that good faith in contract causes a duty, but nonetheless, I can take into account in the broadest sense the existence of a duty of good faith, then our answer to that is no, you can't. And indeed, actually, we say that the existence of a purely contractual duty of good faith is inimical to the existence of a quasi-partnership, because it's another example, of which there are many throughout the shareholders' agreement, of the parties making very specific provision as to how their relationship will work. they have made provision that it will operate pursuant to, in some respects, pursuant to a contractual duty of good faith. That is not, as the Court of Appeal there finds, that is not tantamount to or equivalent to the nature of the duties owed between partners, which is what we're looking for essentially here in my submission.
And I suppose what you might say is that the fiduciary duty of good faith in a partnership arises out of the relationship of partnership. You don't need any express term because it's inherent in the relationship that each partner will act towards the others with good faith. Here, the very fact that you find it necessary to put it into a contract rather shows that you don't have mutual trust and confidence. Otherwise, what are you having a contractual obligation?
My Lord, with respect, yes, absolutely. And that I think as well, with respect, feeds into the general point that what this is a normal example of parties sitting down and allocating the risks and obligations within a commercial venture on a purely commercial basis. The comparison, which I think your Lordship's alluding to, is where there is a partnership, I don't need a partnership agreement of any kind at all. The very open-ended fiduciary obligations would exist by virtue of the relationship. Here, the court is trying to find a relationship from contractual provisions that don't come anywhere near encapsulating the rights and obligations that would exist without formal agreement in a true partnership, to use that term.
Yeah.
So we say, in conclusion, on good faith, and we do strongly suggest that that's at the very heart of the judge's reasoning, that so far from pointing to the existence of a quasi-partnership, it's contrary to that existence. Now, I take the other factors in turn as they arise in para 159. The court will no doubt have noted that the findings as to this important issue are somewhat compressed into one paragraph. It isn't always easy to discern exactly what it is the judge is getting at, but I'm going to try and take the specific issues in turn. And so the first one, I think, is entitlement to be directors. So that's the first sentence. All of para 159, all the shareholders are entitled to be directors. And it would seem that the judge is then linking that to a few lines lower down. There was no means of forcible buyout. Actually, let me just, sorry. No, sorry, I think I'm making a bad connection there. Just having one moment. Yes, I'm so sorry. If I could direct the court to 2 lines up from the bottom of para 159.
2 lines up. Each
2 lines
shareholder entitled to
shareholder is
participate.
entitled to, in inverted commas, participate in the conduct of the business. Now, it's not entirely clear from 159 that links directly back to all the shareholders are entitled to be directors, but it may be a reasonable assumption that that was the intention.
Well, I think what he's doing, isn't he, is quoting from Mr. Hollington's book, which he sets out at paragraph 96.
Yes, those words are definitely quoted from Mr. Hollington as being a hallmark, potential hallmark of a quasi-partnership. But where I think he gets to say that, i.e. that each shareholder was entitled, is by reference back to his own words at the beginning of 159, all the shareholders are entitled to be directors.
Yeah.
I'm assuming that that is the basis of that later observation. But the problem with that is, even if it were a highly significant factor, and we say absent the existence of the relationship of trust and confidence in the first place, you just don't get here. But it ignores the substance of the relationship as found as a fact by the judge himself in paragraph 6 of the judgment. So if we go back to paragraph 6.
Well, it's 5 to 7, isn't it? It says the main decision makers were
Yes, absolutely.
Then he says all the other shareholders are also directors, and then he says day-to-day management divided by Cotterill and Dodson.
He does say that, my lord. What I really wanted to focus on was paragraph 6, because it goes to this question of the directors all being entitled to participate in the business. He says this: for tax reasons, all the other shareholders were also directors. So, just pausing there, my lord, if we're looking at the reality and the substance of this to see whether the facts and matters on which the judge relies actually point to a quasi-partnership or not, the judge relies on the ability of all the parties to participate, the entitlement under the contract, but he himself finds that, in the following words, this did not reflect the lesser roles played by them in the business. And then he goes on to analyse those roles. Alan Cotterill was Mr. Cotterill's son, toolmaker and mechanical engineer, and he worked on the technical side. Mr. Collins, experienced technical engineer, but confined himself to the technical aspects of the business. Murray Dodson was Mr. Dodson's son. He had no technical qualifications and carried out comparatively menial duties at Key. So my submission is this: that reliance on that, reliance on the expressed entitlement, when you're looking to discover the real relationship between the parties, is misplaced when there is a finding that the purpose of that provision was simply for tax reasons and it conflicted with the reality. And that's a finding of the judge. And of course, again, when one's looking at the different roles and participation in the business and whether that can give rise to a partnership or something looking like a partnership between these various individuals, first you're entitled to take into account those matters. Were these people really partners when one of them was described as being just a menial, performing menial tasks? That's one cluster, the technical role and the menial role. The other group, of course, although it only constitutes one person, is...
Well, Mr. Murray Dodson seems to have been carrying out comparatively menial duties in a different company, isn't he?
Oh, is that the reference to a Key?
Yes.
Yes. So, I'll fall to your eye then, on the judge's findings. But then the other group, if you like, is Mr. Shield, who comes at what is being described as a partnership from a completely different angle, from without any prior history in the matter, and with roles that are capable of being competitive. And I addressed you the court on that earlier on, so I won't repeat that. But it goes to this question of the significance of a clause that simply announces that everybody's entitled to be a director, and from that, well, the judge relies on that as part and parcel of his analysis of quasi-partnership to say, therefore, this meets one of the hallmarks. Everybody's entitled to participate in the business. And in my submission, if that had been properly followed through and reasoned out, there is no possibility that the judge could sensibly have arrived at that conclusion. It feels like one of those instances where just something else is sort of added on to that central conclusion. And it's worth just picking up one point in my learned friend's skeleton argument as regards that issue. He says in paragraph 49 of his skeleton argument.
49, did you say?
Paragraph 49, yes.
Yeah.
second sentence, the judge stated that the fact that this was driven by tax considerations was not material. And then he quoted paragraph 159 and said there were no means of forcible buyout, which really isn't the point there anyway. But nowhere can I find the judge saying that the question of tax reasons was not material. It's possible my learned friend is referring to the first couple of sentences of para 159. The judge rather jumbles things up, to be fair. All the shareholders are entitled to be directors. Mr. Reed argued this was purely for tax reasons. Now, pause there. That's not just an argument of Mr. Reed. The judge has accepted that in paragraph 6 of the judgment. There was no pre-existing personal relationship between the directors. Therefore, there was no association formed on the basis of personal relationship. I disagree. Now, that, in my submission, is not a disagreement with the proposition about the tax reasons. It can only be a disagreement about the conclusion from the premise that there was no pre-existing personal relationship, that there was therefore no association formed on the basis of a personal relationship, because the judge's view is there may have been no prior relationship, but one arose at the time of the contract. That's what he's disagreeing with in my submission. It could only be what he's disagreeing with.
Isn't he also disagreeing with the purely, isn't the point the judge making, rightly or wrongly, that as he acknowledged in paragraph 6, for tax reasons, the other shareholders are directors. The point Mr. Reed was making there wasn't just that that was one of the reasons they were directors, it was purely for tax reasons. And the judge is saying, and summarising Mr. Reed's submission in those 2 sentences, in the 3 sentences, and then saying he disagrees. That's how I.
But in my submission, my lord, that is contradicted by the finding in paragraph 6. For tax reasons, they were also directors. However, this did not reflect the lesser roles played by them in the business. So, my lord, I would submit that we're in a little difficulty because the reasoning is somewhat compressed, but the reality is that however you cut it and whatever the judge was actually trying to do or not do, the substance of the fact remains that he's made these findings about the roles of these individuals, and it doesn't even seem to have been contentious. And in my submission, it's not open to the judge to use that as a significant factor in his assessment of the various factors that go towards quasi-partnership. And I think the next factor that the judge identifies in paragraph 159 is the no compete clause. So none could compete with our IAEP on turnkey projects. And so again, there's no sort of reasoning in relation to that. If you look at the exercise the judge was carrying out, he was referring back to the passage from Mr. Hollington, which identified some of the hallmarks of a quasi-partnership. This was not one of them. A non-compete clause was not one of those hallmarks, identified as being a relevant factor. I have found no reference to a competition clause in a contract as constituting a factor in analysis of quasi-partnership in any other authorities. And as a matter of principle, it seems to me clear that it can't. It's a simple contractual provision. And again, it really goes back to that underlying point that these are parties who've worked out how they want their relationship to work. And they've provided for non-competition in the most standard of ways. And it's indicative in my submission of the error into which the judge has fallen, that he even seeks to rely on something, on a clause such as this, which in my submission simply couldn't go towards the issue of whether there's a quasi-partnership. There is a suggestion, just so that we're complete here, in relation to quasi-partnership, in paragraph 162 of the judgment, and the judge is here talking about the continuation of the quasi-partnership relationship after the expiry of the option, and he says in the second line, the non-compete and business promotion obligations continued. And it will be recalled SES was bound by the terms. So there's a suggestion there, again, it is no more than that, that the business promotion clause may have relevance to the question of quasi-partnership, because that clause continued after the expiry of the option, so says the judge, and so too did the quasi-partnership arrangement. So he links the two. Not altogether too clear, but important to deal with it though. Just to pick that clause up, it's clause 2.3 of the shareholder agreement, going behind tab 14.
We've got it quoted at paragraph 22 of the judgment.
Yes, I mean all of these clauses are there, my lord. If that's a more convenient place to look at it, by all means. So the clause reads: each party shall use its reasonable endeavours to promote and develop the business to the best advantage of the company. Again, same starting point is same points that apply to the non-compete. There is no reference in the passages from Hollington to this as being a factor. I have not found any reference to any authorities that support the suggestion that it might be, and as a matter of principle, a contractual provision of this kind in my submission cannot be a relevant factor. It's important also to note that in his consideration of this issue, to the extent it is a consideration rather than a reference in para 162, he doesn't actually refer to the precise terms of the business promotion clause. As we've just seen, it is a reasonable endeavours clause. In other words, it's quite clear that there are limits, and the parties have agreed those limits as to how far a party has to go to satisfy a reasonable endeavours obligation. And those obligations do not extend, for example, to subordinating personal interests. Now, there's a little bit of disagreement about the differences between best endeavours or reasonable endeavours and reasonable endeavours. In this respect, we've referred to this as an argument of paragraph 37. The conclusion there, we say, is that on no basis could the lowest tier of these obligations give rise to any requirement to subordinate your own interest, even though the authorities suggest there may be some limited requirement in respect of best endeavours and possibly all reasonable endeavours. But as your Lordship's textbook clearly indicates, the reasonable endeavours is at a stratum significantly lower than all reasonable endeavours and best endeavours. So one can tinker around up to a point with the distinctions between those various terms and the extent to which best endeavours or reasonable endeavours gives rise to some liability to subordinate your interests. But on any view of the matter, reasonable endeavours to do something within the business comes nowhere near the full-throated obligations, if you like, that would exist as between partners to promote the interests of the business. And the obligation arising out of that fiduciary duty to subordinate your interests to those of your partners where necessary.
So the point you're making, have I understood this correctly, is that if there were a quasi-partnership which involved fiduciary duties as between the various shareholders, then those fiduciary duties would compel each shareholder to subordinate his own interests to the interests of the group as a whole, because that is the nature of a fiduciary duty. So to cast the endeavours obligation at what you've called the lowest tier of the hierarchy of such obligations necessarily means that the parties are not accepting an obligation which requires one to subordinate his interests to the group.
Yes,
that's the point.
That is the point. And I think it can just be expanded slightly in this way, that what we can't do is start from a premise of quasi-partnership and look at the agreement to see whether it's consistent with that. the judge's exercise should have been to look at the terms of the agreement and see whether it gave rise to the relevant rights and obligations. And there is a little bit of a danger in approaching it from the point of view of trying to find out whether the agreement is consistent with quasi-partnership, as opposed to the other way around. What is it in this agreement that the judge is entitled to rely on to say this relationship arose? And he specifically, albeit a little obliquely and by reference, points to that clause. And if that's what he's relying on, we submit that the whole approach is deeply flawed. And then the final point I think that the judge relies on, just put that down, is what he describes as no means of forcible buyout. Now, that was where I was before when I was getting myself slightly confused. So it's about halfway down 159. There was no means of forcible buyout, so it's, and this is the quotation, if member is removed from management, he cannot take his stake and go elsewhere. And that is a reference back to one of the hallmarks of quasi-partnership referred to in the Hollington text. Now, the judge doesn't actually explain what he means by this, as your lordships can see there, but I'm assuming, again, that what he's referring to is clause 10.1 of the shareholder agreement, which I know he has set out, but otherwise it's to be found, obviously, I think it's page 58 of the bundle. And it's under the heading transfer of shares. And it says no shareholder.
I got completely lost with this, not least because all the cross references seem to be wrong.
Oh dear, I'm very sorry about that.
When you go to the articles, it's very difficult to work out who can do what, because it talks about fair value in accordance with Article 18 or something, and there's no such thing, but there is something in Article 17.
Yes, articles.
If you're going to unpack all this, I think it needs a bit of careful explanation about who can do what.
Right. Well, I think I can cut through it in this way, though, my lord. I'll definitely do that if it remains necessary. But let me just. If we look at Article 1.7 of the company's articles, and I think those are at page 148
Yes.
of the bundle. Your lordship sees that the model articles shall apply to the company except insofar as they are modified or excluded by these articles.
Right.
And then you see 1.8, 1.9, the ways in which they are modified.
Yes.
And then, if we look to the provisions on transfer within the articles, which I think are at 17. Yes.
17.
Yes, Article 17. Now, beginning at page 154. So what we see in my submission is fairly standard provisions as to transfer of shares and offering them to the existing shareholders, etc. And then you get to Article 17.13, which is any sale shares not accepted by any of the members pursuant to the foregoing provisions may within the following 28 days be offered by the Board of Directors to such persons as they think fit. Then we go down to 17.16.
So that's the directors selling the shares. not the shareholder.
I'm sorry, my lord. This is sale shares, so,
Yes, but they may be offered by the board of directors, not by the shareholder.
yes, well, I think the shareholder has to go to the board of directors in the first place to transfer, and then it's referred in this way.
And what is fair value?
Fair value, I think, is without a discount. I think it's defined that way. I'll check that.
Well, I was trying to find a definition.
17.10.
1710.
17.10 of the articles.
Oh, my various
1710.
people. Thank you.
Yes. Right.
So we then go to 1718.
17?
16, my lord.
Yeah.
Myself. If the company shall not, within the prescribed period, find purchasers willing to purchase all of the sale shares, it shall give notice in writing to the proposing transferor, and the proposing transferor may then at any time during a period of 45 days transfer all the sale shares to any person by way of a bona fide sale, etc. It's important also to note that if we just look farther down that provision, just towards the last couple of lines, the directors may, and without assigning any reason therefore, decline to register any such transfer contemplated under this article.
Yes.
My friend draws attention to the reference to fair value again in the middle of that provision. So, my lord, the position is this, that there are, we say, the normal preemption provisions for the transfer of shares. They are ultimately subject to a director's refusal to register, but we say that has no bearing in these circumstances because the model articles themselves contain precisely such a provision. I'm afraid that the model articles aren't before the court, but I hope there won't be any dispute that it's Article 26 of the model articles, and subpara 5 of that article provides the directors may refuse to register the transfer of a share, and if they do so, the instrument of transfer must be returned to the transferee, etc. So it's a very standard provision in my submission that the directors have that right, and of course it's always subject to the exercise of the directors' fiduciary duty to the company to act in the best interests of the company for a proper purpose, etc.
Might it be said against you on this point that if fair value is value without minority discount, then in practice you'll never find anybody who will pay that?
Well, I wouldn't want to comment on what may or may not happen in practice, my lord, with respect. I mean, that will obviously depend on the circumstances of the venture, the interest of the potential purchaser, the timing of that in relation to the development of the venture.
Yeah.
But I would say this on that point, my lord, that it's again, these are pretty standard provisions. So if the judge was having to sort of place any material weight on these sorts of provisions, that would be pretty extraordinary, because it would render, in my submission, a whole host of companies subject to quasi partnership obligations in circumstances where they have absolutely no connection with such an arrangement. So as a standalone basis, we submit it has no weight at all, merely reflecting standard provisions. So the point is this, really, that both the model articles and the specific articles permit transfer. They both contain preemption rights, and they both contain a right of refusal. And the court has my point that in those circumstances, this again is fairly standard provisions, arrangements as between shareholders to what in the end is a small company. And that's what one has to have regard to in thinking about provisions of this kind, the perfectly proper contractual reasons for wanting to restrict who could come in and be a shareholder. That has nothing to do, there's no need for any implication of partnership to justify or explain that arrangement.
Where does the judge get his forcible buyout from? Well, why do you need a forcible buyout clause? If in fact you can sell either to existing shareholders or to anybody else, if the shareholders don't want the shares, why do you need to?
Subject, and just so we're absolutely clear, and to be fair, subject to that right of veto by the directors.
Yes.
The problem is, my lord, that the judge hasn't explained. I'm not trying to duck it. I would gladly offer a reason. The only reason I can think of is that the clause itself says, the clause of the shareholders' agreement says, you can't transfer, save to the extent consistent with the articles.
Well, if you go back to the quotation from Mr. Hollington's book on page 98 of the bundle,
Thank you.
he talks about a restriction on the transfer of the member's interest in the company so that if confidence is lost, he cannot take out his stake and go elsewhere.
Right.
He doesn't talk about forcible buyout.
No.
It's just you can't sell.
Absolutely. No, I mean, I agree, my lord. It's difficult to really sort of follow through what the judge appears to be relying on, and follow it back to the relevant authority, and in a sense, by taking the court through those various steps, I've simply tried to show that even though the judge hasn't identified it, there's nothing here anyway. And I know my learned friend didn't pick up this point in his own skeleton argument. He hasn't addressed the enforceable buyout point either. So it is a bit of a mystery, but to the extent one can strand out the various lines of reasoning, as it were, in my submission, it goes absolutely nowhere. And it does seem to rather fall again into that category of you make a central determination as to trust and confidence based on the good faith clause, and then sort of slightly scoop in other characteristics of the agreement in support, but they don't offer that support. So in conclusion, in relation to quasi-partnership, we say the judge failed to look at the relevant relationship in the round, make proper findings of fact and consider the relevant principles. Had he done so, he could not, we say, but have found that this was not a quasi-partnership.
Yeah. Now we go on to ownership of the technical library.
My lord, yes, absolutely.
And it wasn't argued, and isn't argued, that the technical library was comprised within the debenture. That's right.
I think that is, well, it's certainly right, it isn't argued. You just set my mind racing on it, whether, but it's certainly right that it hasn't been argued by me, and I'm not aware that it was argued below.
I can confirm it wasn't a point taken by the appellants.
Have to think about looking at that at lunchtime.
Well, it's not a ground of appeal.
No, quite right. So no, it confirmed. So we say in relation to this ownership of the technical library, it would be a ready conclusion to look at what the judge has done and say, well, this is all about fact, isn't it? How are we, the appellate court, supposed to deal with that? And I quite understand that as a starting point. But our position is that the essential fact-finding exercise necessary to determine who owned what has simply not been carried out. And to the extent it has been carried out, it is fatally flawed. One of the consequences of that is that the expression technical library has been used as a compendious term. True it is that separation is made between three copies of it, three versions of it, call it what you will, and those are the archive, the shop floor, and the machine-based ones. That distinction has been made, but I would submit not in any significant way followed through. But what has happened that is still worse than that is that conclusions about the overall technical library, in inverted commas, have been made based on assumptions or findings. I'll say findings in inverted commas for the moment because I challenged them, but in relation to lines, that's lines of the machinery, that don't constitute all of lines 1 to 6. So in other words, the term technical library has been used as though it's a complete thing for lines 1 to 6, where it manifestly, even on the judge's own findings, is not. And so it's those kinds of issues that I want to address the court on, rather than simply saying, well, we said this at trial, and the judge said this, and he was wrong. That's not the exercise that I'm going to go through.
So if let's assume for argument's sake you're right about this.
Yeah.
We'd have to send it back, would we, for a proper fact-finding exercise to be done?
Well, I have debated that, and that of course is an entirely appropriate and fair question. I think the answer may be twofold. In the first place, it has to be recalled that it only matters who owns the technical library if it was the company that owned relevant parts of the technical library. So if, for example, Mr. Dodson's own statement that he owned certain elements of the technical library is right or is wrong, doesn't matter, save to potentially displace the finding that the company owned it. So if the judgment doesn't come up to showing that the in a proper, sustainable way that the company owned it, or it again, I'm falling into the trap of the relevant technical information, then we would submit that the burden of proof hasn't been discharged, and there can be no breach of anything based upon the transfer of the technical library. Behind that, if the court is concerned, as I say it should be, by the nature of the findings made, but can't go so far as to say, but clearly that the burden of proof has not been satisfied, then I think the only answer is that it must be remitted. And I would, of course, urge the court to take that step if necessary.
Yeah.
If necessary. Not be, in other words, be put off by the fact that that may be the inevitable consequence if certain of the points I'm making are right. So, obviously, it's critical to look very carefully at what the actual findings of the judge were. And I want to start with what I submit as a clear and specific example. And that example is in respect of lines 4 and 5. Now, it will be recalled, and I can take the court to this in just a second, that lines 4 and 5 were the ones that were not collected from the BMW plant at Hams Hall, and they were located respectively at BMW sites in Austria and Germany. And just for your just for the court's reference, I'm sorry, we look at paragraph 9 of the judgment. And you will see, just below halfway down, lines 1, 2, 3 and 6 were all at BMW's engine manufacturing site. Line 4 was a BMW site in Austria. Line 5 was in Germany. So just continuing the focus on lines 4 and 5 for a moment, if we then look at the judgment of paragraph 141, the court will see these words: there is no evidence about the shop floor and archive copies of the technical libraries for lines 4 and 5. The witness evidence was about the technical libraries at Hams Hall. So already in my submission, any observations about the technical library as a compendious term must exclude lines 4 and 5. And in this respect, my learned friend's skeleton argument is in my submission revealing. So if we look at his skeleton argument at paragraph 107, does the court have that beginning the reason?
Sorry, just a minute, I'm behind you. 107.
107, please.
Yes.
So my learned friend says this, that the reason that the judge found what he did in 141 that we just looked at is because the appellants provided no disclosure on lines 4 and 5, and therefore all he was concerned with was the TLs that were recovered from Hams Hall. This is the company's TL that was given to SES for no consideration, and therefore caused unfair prejudice to the respondents. Now, there are a number of points to be made about that. The first and most obvious point is that it appears that the learned friend is accepting that the TL, the technical library, on the judge's findings excluded lines 4 and 5. Now, he may not be saying that in reality they excluded 4 and 5, who knows? But what he is saying is the judge was only concerned with 1, 2, 3 and 6. And therefore, whenever we talk about technical library, whether it be shop floor archive or otherwise, that already has to be borne in mind. And my learned friend says, well, that's all because the appellants didn't provide disclosure, but that, of course, is irrelevant. It's the petitioners, the respondents, who've got to prove their case. They have to have a factual, and this goes to other findings, they have to have a factual and legal basis for asserting that the company actually owned lines 4 and 5. No such basis is even asserted, and clearly no findings are made to that effect. Of course, if it were simply a matter of disclosure, the respondents should have made applications for specific disclosure of relevant documents if they haven't been provided. But the real point is that a positive case as to ownership must precede disclosure. There must be a case. This is why we say we own lines 4 and 5. And there is nothing of that, and certainly no findings to that effect. And it's important to note this. One thing that might be said is, well, that's just a question of valuation. It doesn't affect whether there's been unfair prejudice or not. And up to a point, if I had nothing else to say on the issue, save for that, that might be right, save that. The real question, whenever you look for a remedy in an unfair prejudice situation, is to say, what am I seeking to remedy? And you can't get to the remedy stage unless you know what it is that the parties are said to have done. In other words, it's not good enough to say, well, it must have some, even if I can't say anything about 4 and 5, obviously the remaining 1 through 3 and 6 must have had some value, therefore those prejudiced the company, etc., etc. That's no good because we just don't know what we're dealing with. If we look at the judge's findings, he doesn't carve out 4 and 5. He just makes findings about the technical library. So, first point, any concept of the technical library has to exclude lines 4 and 5, the information in respect of lines 4 and 5. But it's then necessary to consider what findings the judge has made with regard to the other lines. And I would just like to pause there for a moment for the note of caution. In paragraph 29D, it is of my learned friend's skeleton argument,
29.
29, it's in paragraph 29 generally. There is, the court will see there, the court was referred to the following evidence in support of the fact that the TL, note, the TL obtained by KD was the property of the company and was not sold as part of the lines. And he sets out a whole slew of things that are said to support that. Now, as far as I can tell, and my learned junior has also checked, the only document in that list of documents there that was actually referred to by the judge and therefore constituted part of his findings was the document at 29F. And that is what the judge called the jubilatory email. The court will no doubt recall the jubilatory email, and I will come to that specifically in a moment. The danger in just dragging up documents like this and listing them out as though they actually prove something is, in my submission, obvious. But it's more serious than that, because if we look I'm not going to take the court through each one of them. We don't have time, and it's not necessary. The point about caution, I think, should be sufficient, but that can be underlined by reference to just a couple of examples. So if we look at 29F, the court will see this. KD, Mr. Dodson, persuades Mr. Billingham to hand over the Master Archive Library. Note the weight of that expression. And the document referred to is at 163 of the supplementary bundle. And the court will see this is a document dated, if you're not racing ahead, it's a document dated the 14th of January 2013. So it's very early on. And we know what it refers to because it says, first paragraph, Kevin has had a great day in BMW with Conrad. He's agreed to supply the complete technical manual archive for the crankshaft, cylinder head and cylinder block lines. Those are lines 1 to 3.
I thought this was the jubilatory email.
Actually, I was just reading thinking it is. Yes, I will want to come back to it.
Yeah.
But it is the jubilatory email, forgive me. But the point remains that it's characterised by my learned friend as referring to obtaining the master archive. And I draw attention, it's not to have a go at my learned friend in any sense at all, but in my submission, this is what's happened with the judge as well. This doesn't deal with the master archive copy in the sense of lines 1 through 6, because lines 4 and 5 had not even been decommissioned. 6 certainly hadn't, that was much later. And in any case, it refers specifically to crankshaft, cylinder head and cylinder block. And the court may recall from paragraph 6 that one can readily identify those as being lines 1 through 3, which were the lines that were available pretty much from the off. Whereas the others only became available much later. So there's a danger already in 29F. If we then just look quickly at 29G, it says, in October 2013, KD obtains confirmation that Key was given the TL. Note again this compendious expression. And we look to page 204. See what's going on there. And this is 22nd of October 2013. And we see again, crankshaft line, cylinder block line, cylinder head line. Does the court see that right towards the bottom? So lines 1 to 3, not the technical library. And then finally, if we look at my learned friend's subparagraph H, in March 2015, BMW confirmed that the TL is not sold as part of the sale of the line. Just pause to repeat that. BMW confirmed that the TL, again this compendious expression, was not sold. They confirmed it wasn't sold as part of the sale of the lines. And page 240 is referred to in support of that.
214.
240.
240.
Yeah.
I haven't got these cross references.
No,
I
I
think
don't.
maybe that
Oh, no.
maybe Mr. Kanguri replaced a skeleton, but
He
I've
did.
still got XXX's in mine.
My lord, a replacement skeleton argument is part of the bundle, as I
Yes,
understand.
I have to say, I was
Right,
provided
it
with one.
hasn't reached my bundle. It may be on the CE file somewhere.
Oh dear, sorry about that. We'll see if we can rectify that as soon as possible.
Yeah.
And with apologies in the meanwhile, but in fairness to Mr. Kanguri, yes, he did provide a replacement skeleton with the references. Were the did you have a replacement for not ours either?
Oh, we've got yours.
Oh, you got that. Would
Yeah.
you just give me a moment?
Anyway, 240. Yes.
And so 240, this is the document that is put forward confirming that the TL was not sold as part of the sale of the line. So it's a document in March 2015. It's from a Mr. Costar at apparently at BMW. It's headed Swindon Machine Upgrade. No idea what the Swindon Machine Upgrade is. It says, it starts at the bottom by an email from Mr. Costar to Mr. Dodson saying, Kevin, feel free to ask anyone you know to contact me. We don't know what that inquiry is about. And then Mr. Dodson, no doubt for his own self-serving purposes at the time, asks a very non-specific question. May I ask, when a manufacturing line is scrapped, such as the engine links at Hams Hall a couple of years, presumably means ago, presumably the sale is just for the machines and doesn't include the technical and manufacturing library. To which Mr. Costar, not asserting that he knows anything whatsoever about the machines in question, says, hi Kevin, generally it is just the machines, as we don't want replicas being made. Now, how that can possibly support the proposition that BMW confirms that the TL was not sold as part of the sale of the lines, I don't know. But what I do say is that it points to two things, really. First, the caution which one has to exercise as regards statements and skeleton arguments that are essentially evidential when there is no support for those in the judgment. And secondly, it appears to reflect almost this underlying lack of clarity and definition.
Well, you've made your point about lines 4 and 5, but as regards the remaining lines, there is a finding, is there not, that these did belong to the company.
Well,
And although you may say the judge didn't specifically refer to these pieces of evidence, an appeal court has to assume that the judge considered all the evidence, even if he didn't mention it, unless there is, I think the phrase is compelling reason not to, or some phrase like that.
I think that's a fair characterisation, my lord. But I am going to come to that in just a moment. But we haven't yet got to that point because what we then have to consider, let me just yes, if we pick it up in the judgment again at 145, just to see how the judge conducted his reasoning. So first he decides that no difficulty with the manuals and hard drives attached to the individual machines. That passed to SES. He says the position is different in relation to the shop floor and archive copies because they were not physically ancillary to the machines. Mr. Shield then, para 147, suggested in his evidence, putting it in lawyers' terminology, it was well understood in the industry that property in the technical libraries would pass. And then he says, I do not accept this. Now, pausing there, my submission is that is not a finding of fact, as in this fact, it is alleged on the part of the appellants that this was the fact. I find, having heard the evidence, this was the fact. This is an interpretation of what are actually broadly agreed facts as to the most of the underlying position. So what the judge is doing is saying that as a matter of interpretation, he doesn't accept those facts. And he then gives his reasons for that. And that's in beginning of the second sentence of 148. And he says, the first reason is that Stuckenberger was a dealer in scrap, so would have had no use for the TL, for the technical library. Now, this is where the emails is the only place really that we seek to rely on evidence that we say the judge didn't look at. But we say that it's actually of critical importance because that wasn't a finding available to him. That was not a finding in essence of who owned what. It was a finding that Stuckenberger had no use for the technical libraries. Whereas if we look at, we'll just take it by reference to page 220 of the bundle.
Supplemental bundle.
Yes, please.
Which page?
220. If we look at the bottom of the page, you see Mr. Stuckenberger, and this is relatively contemporaneous. It's the 22nd of August 2014. And he says, Stuckenberger removed and purchased the assembly line at Hams Hall. In this purchase, we acquired all the equipment and technical information. And that, of course, refers to, one assumes, lines 1 to 3, being Hams Hall.
Sorry, did you say 220?
220, yes.
Oh, yes, I'm sorry, at the bottom. Yeah, I've got it.
Yes, I'm sorry, at the
That's
bottom.
fine, I've got it.
No, my fault. 22nd of August 2014, 1433. And then Mr. Billingham, on behalf of BMW, responds, I now have confirmation from Mr. I think it should actually be Mr. Varnish, that we are able to furnish you with the technical information for the NG assembly facility removed from Hams Hall. Now, the real point is this. Well, there's several points. The first point is this, that there may be some confusion about what was taken away at what time and by whom, in what circumstances. And one can't resolve that from these emails. But that's not the point. What Stuckenberger is clearly saying there is that they bought the information, the equipment and the technical information. And BMW are not turning around and saying, no, you didn't. That's the critical point that comes out of it. Now, I accept this, that in many factual circumstances of this kind, it would be said, well, you're relying on an email from a person who was not called to give evidence, sent to a person who was not called to give evidence, and the court didn't hear any evidence on that. And therefore, we can give it very little weight. And in light of the other evidence before the court has no difficulty dismissing that evidence. And moreover, they might even get to a position that your Lordship suggested a moment ago, where it actually just doesn't appear in the judgment, even though it should have done, but one can assume that's happened. That's not, in my submission, the situation here. Because what the judge is doing in his judgment is making an assumption about the state of mind of Stuckenberg. They were primarily a dealer in scrap. As such, it had no need for the shop floor or the archive copies. But the judge had in front of him evidence, documentary evidence from people with no axe to grind, not as in the email we looked at before, an email where Mr. Dodson actually tries to tee up BMW to say what he wants them to say. These are two strangers to the arrangement, essentially. Mr. Stuckenberger saying, we bought this, and BMW not coming back saying, no, you didn't. you had no need for it, you're a scrap dealer. Now, in my submission, unusually, that does require the judge to have dealt with it, because it's actually the only evidence he had as to the state of mind, and it is an observation or a finding about the state of mind of Stuckenberg that he's making, essentially, in his first point in paragraph 148. So, it's pure speculation on the judge's part. One can see that in the reasoning towards a judgment in certain circumstance, a judge might be entitled to say, well, I have no evidence on the point, but doing the best I can, it doesn't seem to me, from all the other facts of which I'm aware, that a party in the position of Stuckenberg would have wanted the lines and the technical information that went with the lines. But that's not the position here. There's no real foundation, other than the fact they were sold as scrap, in some sense or other. It's not even 100% clear in what sense, but other than that, the judge has no basis for his assumption. But much more importantly, he has every basis to question it. And at the very least, in those circumstances, it's my submission that it was necessary for him to deal with those emails and say why he felt able to disregard them. Because in my submission, he wasn't able to disregard them, and he shouldn't have disregarded them. The second reason that the judge relies on is again not a finding of fact about the passage of title in this technical information. What he says, the judge says, 148 is BMW didn't sell the machines from the various lines. Particularly in line 1, it kept machines back. Mr. Collins accepted that, transcript day 7, page 50, that in such cases, BMW would not release the manuals in any form because the machines were being repurposed for another use, so we didn't have those. So there would be gaps. The respondent's case is that all of the shop floor library and all of the archive library passed, but that's inconsistent with what Mr. Collins is saying. Obtaining all the shop floor and archive libraries would have had to be done in some other way, which is what happened. Now, I confess I struggle to understand that. It may be just my failure of understanding as a basis for saying that the title did not pass to SES. What's being said simply is that whatever passed to SES, there would have been some holes in it. And that is, may not be right, but it's relevant to whomsoever title passed to.
Explain it, Mr. Collins says.
I'm sorry, pardon.
Explain to the court who Mr. Collins is.
The third reason, which...
Sorry.
No.
I'm just trying to work out what I think this means, because your submission essentially is you don't really understand it, so you don't see how it can hurt
No,
you.
of course.
Doesn't this mean, isn't what the judge saying here, that the most that was bought by Stuckenberg was, and I'm going to put a number on it and it doesn't matter, but just to make it simpler, 90% of the machines, but not all of them.
Yes.
I made that 90%.
No, of course. No, I understand.
And therefore the most that your clients can say via Stuckenberger is that they got 90% of the information for the line, not 100%.
Yes.
What they needed to sell as a turnkey was a line which was 100%. A turnkey has to be 100%, not 90%.
Yes.
And the point that's put against you is that the missing 10% of information came via Mr. Dodson and couldn't have come from title from Stuckenberg.
Well, my lord,
I mean, that may be right or wrong, but isn't that the point the judge is making? And isn't it a sensible point?
no, with respect, my lord, I don't think it is a sensible point,
Okay.
but I don't think it is the point that the judge is making.
Okay.
Mary, did you?
No, that
Sorry.
was just that's where I'd got to also.
Right. So perhaps I can try and answer it in this way, that it is right that certainly the the respondent's case that you couldn't do the turnkey without 100% of the library, therefore whatever they had some value. But the critical question is still, what did they have and what is the judge finding they had? And the judge is here, as I read this, using this as a reason to say that Stuckenberger didn't acquire title to the relevant archive library.
But just picking up my lord's point, if the company acquired 90% of the archive,
IAEP, in other words.
sorry?
The company in IAEP.
Yes, that still wouldn't have been any good to it because you need 100% to carry out the turnkey content
Well, actually, that will be, I think, probably a question for the
evaluation.
if we get there. But the answer to that is, we say actually a lot of this stuff is readily available from the OEMs and so on. And of course, until you know, bearing in mind there are 3 copies, until you know what it is the judge is finding the company had and did not have, you don't know which elements of that, if any, the SES already had by virtue of its possession of the, even on the judge's findings, its proper possession and ownership of what I'll call the machine copies. It's just, in my submission, you simply cannot discern the relevant facts that say, this is what the company acquired, this is what SES had, that which the company had was of value because parts of that SES did not have. That's simply not an exercise that the judge is really, in my submission, even trying to carry out. But on these findings, I come back to this point, that these are not, in my submission, findings of primary fact that the court is concerned about undermining, if you like. It's really just the judge looking at things going, well, this is my interpretation. And what he's not doing is saying in that second point, well, I think Mr. Collins did acquire a substantial portion, but he didn't acquire all of it. And therefore there was still a problem with the turnkey. And I think that was your lordship's point. And perhaps my own friend invited me to explain who Mr. Collins was a moment ago. Perhaps I should say this. I think the court knows who he is broadly, but the role he fulfilled in this respect, I'll need to come to this in a moment, is that he was responsible for the gathering of certain of the technical information. He directed, I think I'm right in saying, Mr. Coburn to actually go and collect it, and the judge makes findings about this, which I'll come to in just a moment. So when the judge says Mr. Collins accepted that in such cases BMW wouldn't release the manuals in any form because the machines were being repurposed, there seems to be a real crossing of logic, because the judge elsewhere finds that what Mr. Collins acquired was the shop floor copy, or elements of the shop floor copy, and those belong to IAEP.
Well, it seemed on the face of it to be inconsistent with his finding at 149 that Mr. Cotterill's jubilatory email did acquire complete technical manual archive for lines 1 to 3. And then again his finding at 150. So it seemed odd that the judge seems to find that BMW wouldn't release the manuals in any form.
Well, yes, I agree. On the lines 1 to 3 point, I think I should point this out. My learned friend, I didn't push him aside, but I didn't deal with it at the time because I was in the middle of something. My learned friend said a few minutes ago that the case was presented at trial from the beginning solely on the basis that the technical information in lines 1 to 3, tell me if I'm wrong, were what he called the technical library. Now, I have to say that reading the judgment, I don't discern any. And six. Okay, so in one sense, the points I made about 4 and 5 then are accepted for that reason. But it still presents the difficulty in my submission that this whole fact-finding process is flawed for the reasons that I'm setting out, and there are further ones to come. So I was just going to come to the third reason, which is set out at I think back in sorry, just lost my. Yes, so it's at para 149. Mr. Shield's evidence is inconsistent with what in fact occurred. I have outlined the evidence of how Mr. Dodson was able to get the archive library from BMW and Mr. Cottrell's jubilatory email. If SES already owned the archive library, none of this would have been necessary. SES could have demanded the archive library as of right. So it appears that a lot of weight is being placed on what we've called the jubilatory email. And in my submission, that email simply can't sustain that weight. First, it's consistent not with any question of ownership, of title passing. There's no analysis in the judgment in my submission about how title can be said to have passed. There's also, when one's looking at the circumstances to try and interpret, well, what are these facts that we know about? What are they meant to mean? There's no dispute that all of these lines, and by these lines I mean lines 1 to 3 at the moment, which is what the jubilatory email is concerned with, were taken to Oldbury. And Oldbury is SES's premises. And that's where all the machinery was and all the technical information was. But on any view, of course, even taking the concession as regards lines 4 and 5, this does not concern line 6. The jubilatory email had nothing to do with line 6 because it was in 2013, way before line 6 was commissioned, and there's no suggestion or evidence that the jubilatory email refers to line 6. And even if you just pause there, this email provides no evidence whatsoever of the ownership, of rather who owned the elements of the library in question. So it's this jubilatory email, oh very good, we've got it. But what does that tell us about who owned the library? At this point in time, certainly in a period of time close to this, Mr. Dodson, as the court will no doubt have seen, was asserting that he or his company owned the technical library. That was his case and evidence for quite some time. So how can it be derived from this jubilatory email that SES were not claiming title to the archive library? SES, I think I'm right in saying, by Mr. Shield, were not even party to that email. And yet what the judge is actually doing is saying that the final sentence, if SES already owned the archive library, none of that would have been necessary. SES could have demanded the archive library of right.
So just to follow through what happened to these machines, they start off in the possession of BMW.
Yes.
BMW sold to Stuckenberger, Stuckenberger to Pegas,
Yes.
Pegas to SES.
Yes.
So the company, IAEP, never has possession of the machines.
Save for
Is that right?
That's my understanding. Only one caveat to that. It appears that Mr. Dodson himself had and has possession of the technical information in relation to line 6.
So I'm not talking about technical.
But as regards the
I'm talking
lines,
about the machines.
machines were always in the possession of the company,
So
as I understand it.
No,
SES.
not right.
It's not right. The Oldbury premises where the machines were stored and the technical library was stored were premises that were the storage site for the company IAEP, and that's where possession was.
Well, I have to say those
I
were
was, sorry, I was
instructions.
looking at paragraph 145. He says, property parts from the machines, they pass to SES, chain of title BMW to Stuckenberger to Pegas to SES, completed by physical removal of individual lines from BMW to storage arranged by SES. That's the finding.
My lord, may I just assist on this point? It may help.
Yeah.
I don't want to interrupt my learned friend's submissions. The line 1 and 2, which were the lines that were completed, the purchases of late 2012, early 2013, were obtained and taken into the storage facility in Oldbury, from where the company was effectively trading and sorting out machinery and refining them. The technical libraries themselves, the judge found, would have had some manuals in their cabinets, etc., for the individual machines that would have been required, both in floppy disk type, digital format, and hard copies, but were not all. There was no evidence before the court as to what was there and what wasn't there. The crucial point was that the lines needed to be operational at the end of the day.
Needed to?
Be operational in order to produce the engine for engine.
Yes.
So in order to do that, you didn't need manuals in respect of each particular machine. You needed the manuals to put all the lines in the production of the...
Yes, you need to, the overall arrangement.
Yes. So there was a second copy of what is loosely defined as the technical library in respect of the lines 1 to 3 at Hams Hall, which were the engineer's shop floor copy. That's the copy where Mr. Collins says, well, some of that wouldn't have come across to us. The third copy, which is the full master archive, which is, as everybody understood it, both appellants and respondents during the course of the trial, was a full copy of the library, is the one that was obtained post-sale of the machinery to SES by Mr. Dodson from BMW in January of 2013. And that was then taken to the same premises where the lines were stored. And I mean, there were pictures in the trial bundle that it was many hundreds of volumes of files.
So the company's interest in acquiring these manuals was as the holder of an option to acquire the machines.
Yes.
Is that right?
Yes.
So it didn't, which you never exercised.
No, he was never in a position to exercise the option.
Yeah.
And conversely, of course, my lord, SES's interest in acquiring that technical library was as a natural adjunct to the asset that it in any event owned, and if the option were not exercised, would have in due course to sell. My point really here is that the circumstances, even as found by the judge, do not permit the judge to put the weight he does on the jubilatory email. It doesn't concern SES, and I was going on to make the point that entirely consistently with ownership by SES is what the judge actually finds, that storage was arranged by SES. Now, it had been my understanding that Oldbury premises were at least paid for by SES. If I'm wrong about that,
It's where the company traded from.
all right. If I'm wrong about that, I apologise, but the point is that SES arranged for that storage, and that is entirely consistent with them acquiring exactly what you'd expect them to acquire, namely the technical information that goes alongside the lines that they had bought, and the lines that they had bought. So then, that's why we say, essentially, the judge couldn't put the weight of evidence he did on the jubilatory email. And bear in mind, quite apart from anything else, it only refers to lines 1 to 3. 4 and 5 have gone, but it certainly doesn't refer to line 6.
Yeah.
And then we've got the second of what the judge described as the following paragraphs. You recall at para 148, he said that would have to be done in some other way. This is the final sentence, which is what happens, see the next paragraphs. I've dealt with the thirdly point at 149, And then he goes on to say this in para 150. So far as the shop floor library is concerned, obtaining the manuals, etc., also seems to have been a matter of leaning on BMW's goodwill. Mr. Collins' evidence, this is what we were touching on just a few minutes ago, transcript day 7 pages 50-51, was as follows. Now, I'll take you to the relevant part in a moment. Just to observe, I don't think that reference to the transcript is in the bundle, unfortunately, but I don't think there's any dispute that the period of time, because this is a question put by Mr. Kangure, because no time is indicated by the judge, the time was between September and the end of the year 2013. That's what you actually put to him. So it's reasonably early, in other words, but just to locate it chronologically. So he gives this evidence about the machines being scrapped, for want of a better word, on site, and he goes on and he identifies the information, the machines in respect of which the information was important. And so he talks about the crankshaft normalizing oven, the induction Hahn, the crankshaft induction Hahn machine. Mr. Coburn went to the lines under instruction of myself, verbal instruction, because we had many conversations, and I said, look, Nick, I need these manuals from the normalizing oven and from the induction Hahn machine. Nick went around, sourced manuals from the process, etc. So what we have is very limited evidence of what Mr. Collins actually gathered at that point. It only appears to concern what I think is line 1, things connected with the crankshaft. It certainly, as we know, doesn't relate to lines 4 and 5, and clearly equally not line 6, which was decommissioned sometime later. So we say that of itself provides no evidence of ownership of the lines, the basis on which title passed, or indeed any evidence as regards anything other than a very small subset of documents collected by Mr. Collins. So doesn't, where the judge says, going back to para 148, the respondent's case is that all of the shop floor library and all of the archive library passed. This is inconsistent with what Mr. Collins is saying. Obtaining all, note, the shop floor and archive libraries would have had to be done in some other way. That is what happened. See next paragraphs. And first, we've just got, of those paragraphs, we've just got the jubilatory email, and second, we've got this very partial information, which is not at all to do with obtaining title. It's only about possession, collection. And of course, the judge relies on the fact that Mr. Collins himself, I think we'll come to this in a moment, says, as you'll see in the final sentence of para 150, there were some holes in the library, and that's why I was pleased with Mr. Dodson being able to have permission to collect the manuals on behalf of IAEP. And it appears that the judge places some reliance on that, but in my submission, without more, the statement of a layman as to who you're acting on behalf of in circumstances such as these is clearly not a reliable basis for an important finding of fact. And indeed, we see the difficulty with that from the position I mentioned earlier on, which is that Mr. Dodson himself asserted for some considerable period of time that he was the owner of the archive technical library. And we say that the position is similarly problematic in relation to line 6. Again, the starting point is there are no factual findings on which a determination could be made that the company acquired title to line 6. And that's as regards the archive copy, just starting there. As regards the shop floor copy of line 6, there doesn't appear to be any evidence whatsoever. Now, as regards what appears to be the archive copy, it was Mr. Dodson's evidence that line 6, this was his evidence at trial, that the technical information in respect of line 6 is still in his garage. We mentioned this in paragraph 80 of our skeleton argument. I noted actually when I was looking back at the reference myself that the reference only included the reference to the next bit of the cross-examination. Now, I note my learned friend hasn't taken issue with that. It was his, he was present, so I don't know whether he's happy to accept that Mr. Dodson said that the archive, that the relevant library was in his garage still.
Line 6 was obtained much later.
Yes.
And is still in Mr. Dodson's garage on behalf of IAEP.
Right.
And that is along with, just to be absolutely clear, the technical information connected to line 6. And my learned friend is confirming that.
I'm sorry, I should have made clear. I'm talking about the technical library only, not the machinery itself.
Ah, okay, sorry, yes.
I don't think it would fit in your standard garage. If it were.
It would have to be something of a big garage, yeah, that's my mistake. Yes, the point is the technical library for the archive copy, as I understand it, or what is asserted to be the archive copy, is still in Mr. Dodson's garage. And of course, we know that line 6 is the more important, or the most important of the lines, and that was the evidence of Mr. Shield, which was not rejected, or I'm not sure it was actually challenged by the other side. But in any case, we refer to that evidence at paragraph 80 of our skeleton argument. It's necessary to pick that up just for reference. We make the point, and the cross-examination is there, or the examination is there in the Bible. So, it's important in that respect then to note that the judge himself doesn't even find that the archive copies of the library were transferred to CGI. He relies only on the shop floor copies. You know, we get that from paragraphs 173. Paragraph 173. The judgment. This is where the judge is talking about fiduciary duty, breach of fiduciary duty in relation to the technical library. The giving of the shop floor library to SES and CGI for no consideration was a breach of fiduciary duty. And again at paragraph 177, if you look at the third line, no meeting of directors was held to ratify the transfer of the shop floor technical library. So we're not, on the judge's finding, apparently concerned with the archive copy. And as I've said, there's no evidence in my submission as to any acquisition of title to the shop floor copy of line 6. The shop floor copies are the principal focus of the judge's judgment in respect of those are the evidence of Mr. Collins. And it's quite clear that the evidence of Mr. Collins, which referred to the period at the end of 2013, bore no relationship whatsoever to line 6, which was not decommissioned until some considerable period later, and in any case didn't involve the items to which specific reference was made in the judgment. So it can only be when this expression, the technical library, is being used, and it is used as the court will see in those two examples I've just given. That, just to go back to them for a second, where in 177, for example, no meeting of directors was held to ratify the transfer of the shop floor technical library. No definition of that to exclude certain elements of it. Simply reference to the whole thing.
Isn't that because the judge is relying on the evidence of Mr. Collins when he collected the shop floor library, which amounted to 95 or 98%, and on behalf of the company?
Well, first point, my lord, is that could only refer, as we've said, possibly to 1 to 3, but more probably to 1.
Well, that's very fine.
And that's what I'm focusing on. So what I'm saying is, our point is that the judgment can't be referring to the totality of the lines. We say it can't refer to line 6 for the reasons I've given. I said before that even as regards 1 to 3, in my submission, there are no sustainable findings because Mr. Collins, if the entirety of the point is founded on the basis that Mr. Collins says he was acting on behalf of IAEP, that's just attributing an interpretive statement to a layman, which it can't bear in the absence of underlying facts.
Well, no, maybe I misunderstood your submission. I mean, I understand that you say that the judge shouldn't have made a finding that the shop floor library was held by the company on the basis of the evidence that was before him. You say it wasn't enough, and things like the layman, Mr. Collins. I get that. But I thought you were making a different point about 173, but it sounds like you're not. The point you're making is still the same one, that he shouldn't have found that the shop floor library was the company's. And of course, if it wasn't the company's, then 173 wouldn't be right.
No, but I'm making all of that I agree with, my lord, but I'm making additional point that even if it's a very loose use of the term, because even on his own findings, he had only found that Mr. Collins had acquired some element of what at most could be lines 1 to 3, but more clearly seemed to be simply line 1.
Right.
So he's not making any of that distinction. He's not making the distinction there's no evidence in relation to lines 4 and 5. He hasn't carved them out. And what I'm really wanting to say is that that is indicative of an approach to the fact-finding exercise that rather latches on to individual items of evidence, or not even necessarily evidence but thinking, and extrapolates out from that to arrive at conclusions about the shop floor library, the archive library, which in my submission are unsustainable on the facts, even the facts as found by the judge. Qualifying that to say that the findings he makes as regards ownership are not, in my submission, primary findings of fact. They are interpretative statements for which, as I say, in my submission there's no support. What do you feel?
I'm a little bit puzzled by this. You made a lot of the fact that the judge only makes a finding about the shop floor library, but if I go back to paragraph 140 of the judgment, he says that there are 3 copies of the technical library. Each machine has its own manual, so that's copy 1 in its software. Secondly, he says there's a complete set of all the manuals and software kept in the engineer's office on the shop floor, not just documentation of particular machines, but also the plans for installing the whole of the line. Thirdly, he says there's an archive set of all the technical documentation. But if you've got the shop floor manuals, you've got everything, haven't you?
Yes, but that's the point, my lord. You would if you had everything. I know that's somewhat circular.
I thought your point was that the judge hadn't found in the paragraph 179 the archive manuals. Sorry,
Well,
not,
I'm only going on what the
not
judge says then.
179. I'm sorry, it was some other.
173 and 177.
Yeah. That he only related to the 173. That it was only the shop floor. But the archive on the judge's description at 140 doesn't seem to add very much, does it, to the shop floor?
Yeah, but my point is, my lord, that 2 things. First, he hasn't he's
I've
not.
got your
verified.
point about only lines 1 to 3, and it has nothing to do with line 6. I have that. It's,
Well,
just, it's
not
the
necessarily
distinction you were
all.
making between shop floor and archive, which at the moment I'm not entirely following, because they seem to be two copies of the same thing.
They are potentially, but all I'm pointing to is the fact that the judge has not said that there's been any wrongful transfer of the archive copy. That's the only point I'm making there. He
Oh, I
just refers to the shop floor. But it isn't right in my submission to say, well, that's all that actually matters, because the shop floor is a complete copy, for the reasons I think I've said that it isn't. And that there's no proper case for saying that the company acquired the shop floor copy, but in any case, the evidence to which the judge refers has no, does not concern anything other than a relatively small subset
Right.
of that information.
Should I just pick up the archive point, please? Going back to paragraph 140,
Yes.
there is an archive set of all the technical documentation, physical and electronic, kept separately by BMW in secure storage. So that seemed to suggest to me when I read it that therefore we weren't particularly concerned with the archives material, and neither was the judge, because that had been, he found that that had been kept by BMW in storage.
When
And so which is why, for my part, I was content with the phrase shop floors
well,
as defined by.
your ladyship may be right about that.
But it's a finding by the judge.
No,
Are
I
you
mean,
challenging that?
no, it's not that I'm challenging it, but my reading of that finding had been, look, this is how things start off. This is how it's all set up. But it had been my understanding that the respondents were making a case that they had acquired the archive copy from BMW.
Right.
That had been my
As well
understanding.
as
I think
the
my
shop
own friend's
floor.
nodding.
My lady, the archive library, which is the master library effectively containing everything, is the one that this jubilatory email refers to, which was obtained subsequent to the purchase of the machinery by SES.
So the reference in 140 is effectively setting the stage.
It is, yes.
That's how
Yes.
I'd understood it.
And so the shop floor library is the one that Mr. Collins is referring to, which is that because not all the machinery was sold, and because not everything would have been with the machinery, may not have been complete.
Thank you, I understand that.
So my own friend does helpfully clarify the position on the Master Archive Library, saying that the jubilatory email confirms the acquisition of the archive library. But of course, we looked at it earlier on. On its face, it only refers to lines 1 to 3, not to line 6. It couldn't do because of the date.
Yeah.
So if that's the basis, and it does appear to be the basis on which a contention, or the conclusion of the judge, I should say, sorry, the conclusion of the judge that line 6 archive library was somehow acquired, then that doesn't stand up, because that email doesn't give any foundation for it. And what we then have, as far as line 6 is concerned, we have a copy sitting in Mr. Dodson's library, garage, and in my submission, no evidence as regards any other copy of line 6.
While we're focusing on this, can we just make sure I've not misunderstood something in your questions about
Yes.
Part of the argument is that when Stuckenberger obtained the machines,
Yes.
they were entitled to have the manuals that were on the machines because they were physical. Any manual which they got as part of buying the machines, they were allowed to have. I get that. But the fact that that's true, and then ultimately that passes to SES, the fact that the manual that was in a pocket on the side of a machine is sitting there, and so that the person who ultimately derives title from Stuckenberger is entitled to that manual, doesn't mean that they're entitled to a different copy of the same manual. It's a bit like saying I walked into a shop and I bought a book. The fact that I own a book doesn't mean I own another copy of the book. So the fact that SES are entitled to own any manual that was acquired through Stuckenberger as far as I can see, doesn't give them any right to any information that was in the shop floor or the archive.
But my lord, if you're analysing the position absent any factual foundation for ownership of the technical information by any of these individuals, so you've got Mr. Dodson asserting he owns it, you know, or his company initially, and so on. You have to look at what would be the, if you like, the parties' understandings, the probabilities arising out of the objective facts. The objective facts are that SES was the acquirer of the lines with the interest in obtaining the information. Of course, it may be said that the company had an interest, but it would be a curious way of expressing that interest because it wouldn't be consistent with the way the parties had set up their arrangement, namely that the lines were subject to the option, and if the option weren't exercised, then SES would have the right to sell the lines independently. In those sorts of circumstances, it would, in my submission, the natural understanding would be that the lines, the acquisition of the lines included the acquisition of the information. The email at 220 doesn't, is in my submission consistent with that because it says, if I can invite the court just to go back to that for a moment. You see the second paragraph in the email at the bottom. Joe Whitehouse has gone to the archives to collect the information and it has been removed. We're informed you may have already removed it for safekeeping. Please could you advise of the whereabouts of this information? So as I said when I went to this in the first place, there may be some confusion about the question of collection and possession and so on. But Mr. Stuckenberger is clearly saying here, in my submission at least, that he's entitled to the information in the archive. That's why they've gone there and they can't find it. And what doesn't come back is, well, I don't know what you're talking about. We didn't sell that to you.
Well, what the judge, I think, is not concerned with information. As he says at 143, nobody said there was any passing of any intellectual property rights. He's concerned only with the chattels.
Yes, but you don't own those chattels.
Yeah.
There's got to be some basis upon which party A can say, I own those chattels rather than you, and that's not simply by where they're located. It's by reference to all of the circumstances in the normal way in my submission. So this, bear in mind, this is a potentially valuable asset, and SES were paying material amounts of money to Stuckenberger or Pargas for those assets. So again, the natural, in my submission, interpretation would be that they were buying the material that was ancillary, and that's supported by that email, and not, and this is important in my submission, not contradicted by any primary findings of fact elsewhere. And so finally, that just brings you to paragraph 151. And this is really how the reasoning proceeds. Once SES's claim to property in the shop floor and archive library is rejected, the only plausible contender for ownership is IAEP. So I submit that that's the foundation of the finding that IAEP owns the technical library. And in my submission, that is not a proper finding of fact. It's casting some doubt on the ownership of SES. I've analysed that. But it doesn't follow. You can't just default in my submission. You could put it to a finding that it must therefore have been the company. You could put that the other way around. But what if the judgment had proceeded by an analysis of the foundation for IAEP being the owner? And having not succeeded in establishing any proper concrete grounds for that, it would then have said, well, the only alternative, therefore, is SES, and no doubt it would have proceeded to say, which is entirely consistent with the commercial arrangements underlying the party's intentions in any event. And you do see, just a few lines down, the point that as regards the archive library, Mr. Dodson originally claimed he was acting on behalf of Key. Well, if all we're doing is looking at the default position, namely it's not SCS, therefore it must be IAEP, what proper foundation as a finding of fact is there for rejecting Mr. Dodson's evidence?
Well, that's surely for the trial judge.
No, with respect, I would actually take a bit of issue with that, my lord, sorry, but it's not for a trial judge in this sense, that all he does is, my own friend said, well, he resiled from that. Well, we know he resiled from that. But what we're trying to look at is what the evidence of substance before the judge is that allows him to make a finding as to title. And if that is just the say-so of the individuals, then that in my submission is not a matter of substance. In particular, when one looks at the fact that when it suited him, Mr. Dodson said, I'm the owner, and when it didn't suit him because he through the company wouldn't have worked.
Well, a very hard task to challenge the judge on credibility.
Yeah, but I accept that entirely, my lord. But it isn't, in my submission, a matter of credibility. If someone simply asserts what is in the end a matter of fact and law, I was acting on behalf of, that isn't a primary factual matter that I have to sort of overturn, if you like, as far as the judge is concerned. That's just an element that we say goes nowhere. It's just what the person thinks, and we know that in this particular case because Mr. Dodson said, although it's a matter of, we would say, obvious principle in every case.
All right, have we got to the end of this part of your submissions?
I think we have, my lord. Would you just give me a moment so I can just...
If I can just refer you to paragraph 109, where the judge makes the specific finding in relation to the change of evidence by Mr. Dodson. The change results from a realisation that as a matter of law, any acquisition would have been for the benefit of the company run his own country. It doesn't cause me to doubt the overall honesty of his evidence.
I accept that, my lady, but my point is that saying I act on behalf of isn't a question of honesty or dishonesty. It's an interpretation of who you're acting on behalf of in a certain circumstance.
Well, I think that's borne out by what the judge says. It comes from a realisation that as a matter of law, any acquisition would have been for IAEP.
But it's not for Mr. Dodson to make that. That's my point. It's either right or it's wrong, but it isn't influenced by the fact that Mr. Dodson thinks one way or the other.
Yeah.
That's the point I'm making.
All right, was that a convenient moment?
It is, my lord. Thank you, gentlemen.
2 o'clock.
Thank you.